Okay, I guess we'll go ahead and get started. Um, I'm Roger Jackson. I'm on the board of the Rocky Mountain Inventors. We're a 501c3 nonprofit. Been around since 1978 in a lot of different forms and places, but this is one of our better places. So we're strictly educational. We're not here to sell you anything, and we have presentations on a wide diversity of topics. Everything from funding and finance to legal, marketing, social media, manufacturing, general entrepreneurship. We have entrepreneurs come and talk to us. I was looking for suggestions if there's a particular topic anyone's interested in hearing about or anything. Please let me know. I'll see what I can do to get a speaker. We also do some Skype presentations. We can pull in people from other parts of the country or other parts of the world. We've had them on manufacturing experts in China and licensing experts out of New York. And so that we can do interactive through Skype, ask questions and get answers. So that extends our reach. It works pretty decently, really. I'm a patent attorney by day, and I've been in this group since 1999. And we've had a lot of ebbs and flows in membership, but we have a lot of churning, a lot of people in and out. Either they find out that, this whole entrepreneurial thing is more than they want, or they get too busy in their business, and then we don't see them too much. So just for the new people, if your idea is not protected or already disclosed, say with patent pending, be sure to still keep it secret so you maintain your trade secret status. So our speaker tonight's Kevin Cudney. Great presentation on issues, buying and selling a business. I went to it was 4 one-hour sessions of this, so it's in more detail. This is more summary, but it'll give you an idea of how this process works. And in the future, what do we have coming up? We have the meeting in 2 weeks. I have a high-end precision manufacturer coming of aerospace and turbo machinery parts. If you need precision manufacturing, job shop, prototype type work, they're good. They're expensive, but they're more of the high end, and they're local here in Arvada. On the 20th, we have a meeting at the Patent and Trademark Office here in Denver. It's on our website for trademark training. And that's a daytime one at lunch hour. So you can look on our website and see all the events we have in the future. So usually just do a quick round robin, take a minute or two, introduce yourself and how you found our group, what you're looking for. So go ahead, Todd.
So was a fairly active member back in the early 2000s, and got a little busy with other things, but I'm just getting back into the group, so tonight's topic really interested me.
Great, okay. Did you meet when we were over in 4th and Bryant?
Yes.
With Jerry Foreman?
Yeah, and at the library.
Yeah, various libraries around town.
Yeah, this is one we've been at for probably 2 years straight over early 2000s.
Oh, Belmar?
Yes.
Yeah, okay.
It's been a while.
And Dick?
My name is Dick Bowers. I'm the owner of a company called Sci-Fly RC, and we sell products that have to do with flying motor and drones, etc.
Oh, okay. Great. Brad?
Brad Strom. I create media, and I've got an invention that's burning a hole in my pocket. And, I used to go a long time ago too, and it's like my 3rd time back.
Okay. And Mark?
Mark, probably like most of you have come in and out of this thing for close to probably 20 years. And serial entrepreneur, I just
turn it over to Kevin.
Great.
Let you start.
Thanks all of you for coming. So, as Roger mentioned, this presentation is actually, it's a four-parter. So we're going to be really trimming it back to present a lot in a very short period of time. The idea for this started actually a number of years ago when I was looking at one of the local papers that suggested to me that there are 8 important things that you needed to know when you were about to sell your business. I started developing a list. My first list had 64 items on it. The last one I did had 160. So we're digesting this really dramatically. Please feel free to ask questions as we go. This is very much seller-centric, but I think a lot of the points that we'll be making in connection with this are kind of applicable to buyers. But again, ask questions as we go. Much more important that you get your questions answers than what would follow the script here. And the PowerPoint will be distributed by Roger after we meet. So basically, I'm not going to go through the table of contents, but it'll really show you when you see the presentation. It was divided into 4 parts, and there is some method to the madness here. But basically, we're going to be walking through this. So first, we're going to be dealing with the sale process. And I think the thing that you have to remember about the sale process is, although it generally moves in sequence, it is more characterized by speed bumps than anything else. What this essentially means is, you can read all of these how-to books, but the fact of the matter is that what is most important is that, quite frankly, you hire people like me and bankers who know what they're doing, because this is a subject matter that is really it is really captured by and it's dominated by people who know the business. It's knowing the market. It's knowing what will pass as a marketplace deal that is really important. And I think it is one of the things you have to do very quickly is you have to recognize the foibles of the process, you have to identify the members of your individual team, and you have to proceed. I mentioned market. I think one of the things that a lot of people fall into is the idea that they look at what the market is saying as being the most important thing that's out there. So, for example, the first quarter of this year was horrible for the M&A market. Absolutely terrible. And everybody was wondering if this is, kind of a pause button or if this was kind of the way things are going to be. Well, the market has recovered significantly. There are some hot industries, but I will tell you the main thing that you have to know about whether or not your particular company is going to be attractive is basically, do you have a good product? Do you have good management? Are you experienced in the field? Have you hired the right people? Have you put together the right team? Those are the things that are important. One of the first steps you're going to be doing as you consider investors or selling your business is basically entering into NDAs. The most important thing I can say about this, well, 2 things. First of all, a good non-disclosure agreement has 2 elements to it. It has, first of all, non-disclosure. You're going to covenant that you're not going to, whoever is the recipient of information, is not going to tell it to somebody else. But more important than that is that the person who's the recipient of the information is not going to use it for any purpose other than in connection with the particular transaction you're talking to. So when you think about confidentiality, but also think about the second part, which is called non-circumvention. And obviously you have to be very careful who you're sharing information with. Question?
What's an example of someone who's circumvented?
Perfect example, transaction I worked on a couple of years ago as an example of non-circumvention. We had a purchaser who got very involved in the process, submitted a letter of intent, and as we found out, ended up withdrawing from the transaction because, quite frankly, they wanted to go to school on my client, the seller of the business, so that they could compete with them. Non-circumvention. Never disclose it to anybody else outside their organization, but it was always their intention to basically use the information to develop their own business.
Can you maybe parse apart non-circumvention and non-compete?
Well, non-circumvention is really competition really means that you are going to go out and you are going to aggressively, in the same line of business, you're going to aggressively compete with whoever information you have. Non-circumvention is a little bit different. It essentially means you're going to go to school. You're not necessarily going to compete with that person, but you are going to learn about the industry to figure out if you want to compete. I think that's probably the best way to look at it. They really attach together, non-circumvention and non-competition, but remember that as part of a due diligence process, you are going to be required to enter into an NDA, a confidentiality agreement, and that's going to be kind of the first step. Non-competes and other things you enter into later, but at the very preliminary stage, you're going to be entering into an NDA, and non-circumvention is critical at that stage.
I'd say if the deal didn't go through, then you don't want them coming back with your insider information.
Correct, yeah.
So that has to be written into the contract, so that's clear.
The non-contravention should be written into any NDA. And it basically means, again, a good NDA has two parts. I'm not going to disclose it. I'm not going to use it for any purpose other than talking to you. Okay? Putting your house in order. Basically, this is kind of an introduction to due diligence. And the idea about due diligence is very simple. The best due diligence is the kind of due diligence that the seller of a business is prepared for. He's looked at it proactively. Due diligence is not a spectator sport. If you're selling your business, you basically want to be prepared for what's going to happen in a due diligence process. You want to anticipate it. It is much better for the seller to anticipate something that's going to be found and find it first and correct it than it is to have a buyer look at it. Because when a buyer looks at it, what is the buyer thinking? If the buyer really wants the asset, the buyer is thinking, this is a way I can reduce the purchase price. Question?
At the front end of any negotiation like this, is the buyer subject to disclosing his potential ability to actually go through the process and have the wherewithal to actually buy in with the company?
Due diligence.
Does he have the wherewithal?
Due diligence is a two-way street, and what I always do when I'm representing a seller is I am telling the seller, use due diligence to find out what the buyer has. Does the buyer have the resources? Does the buyer have the will? Does the buyer does the buyer have the know-how, the management, et cetera, to really enter into a deal? And that becomes part of what transaction folks call execution risk. You want to make sure due diligence is really, as I said, not a spectator sport, number one, and it's not a one-way street. It's a two-way street. Use the due diligence process to find out about your buyer. Yes?
Is there an easy way to find out about just if they have the resources, other than how many employees they have?
Is there an easy way to find out if they have the resources? No.
I mean,
You asked the question.
right.
You asked the question.
General idea, I mean, if they have 800 employees and they have 1 million square foot of space and they're making stuff.
I can't tell you for sure that there's any one thing that tells you that a buyer is serious about buying. I mean, you have to probe that. You have to, if the buyer is a fund, for example, a financial buyer, you have to find out, do they have the resources to do this? I mean, do they have the resources? Do they have the will? Do they have the management? Yes?
Is there any requirement of the potential buyers to disclose any of that information?
No. The only duty that a buyer has, and the duty that the seller has, is what's called a duty of good faith and fair dealing. When you start opening up a transaction, start having discussions, you're supposed to have a duty to pursue those in good faith, not to lie, cheat, and steal. But if you don't ask, and quite frankly, most sellers do not, there's no requirement on the part of a buyer that the buyer spill his beans. Because if you ask the buyer the questions, the buyer can say, sorry, I'm not going to tell you that, and walk away and play chicken with you.
Is it copacetic? Is it copacetic to have a third party investigate a buyer? There are a lot of companies and a lot of accountants who actually go out and
Third-party due diligence these days is very popular. A lot of people do it. But remember, in order for you really to find out substantive knowledge about a buyer, a lot of times you have to have the buyer consent to it. You have them consent to it. Just like if you are selling your business, one of the first things you're going to be asked to do is to basically allow for a credit investigation, a third-party investigation of you. Buyers are not as willing to do that. So just an example of some of the things you should be looking for when you're trying to put your house in order. Take a look at your contracts. Have they expired? You have no idea how many times as when I'm representing a buyer, I'm looking at contracts of a seller and I find out the contract is expired. I find out that there really isn't a written contract, that's an oral contract. So what you should be doing, you should be taking any oral agreements you have and making sure you got a summary that people have signed that says what in fact is being bargained for. Assignment change of control, nothing worse from a seller's perspective to be selling a business that's based on contracts only to find out that those contracts cannot be assigned without a third party's consent. So these are the kinds of things that you do proactively in terms of preparing for due diligence. IP is I can let Roger speak to this a little bit more, but capturing IP value is incredibly important. Let me tell you the most obvious thing that happens when we are selling businesses, when I'm representing a seller. I say to the seller, do you have patent protection for that? And the answer is, no, I don't. We couldn't afford it, didn't make sense to us, et cetera, et cetera, et cetera. We were outside the window, the one-year windows. So we consider it to be a trade secret. I say, that's great. Tell me what the trade secret is. Well, it's this and this and this and this and this. Have you ever reduced it to writing? No. How many other people know the trade secret? Well, there are 3 of us. What measures have you taken to protect your trade secret? Well, nothing really, the 3 of us know. One of the main things you want to do about capturing IP value is you want to make sure that if you have trade secrets, that it is written somewhere. Buyers pay more for patents than they do for trade secrets unless you've really reduced the trade secret to writing.
What about intellectual property, including engineering work and digital drawings and
It's all
$50,000
trade secrets. You have to use reasonable measures to protect it.
You mean the stuff that's in process?
Yeah,
Yeah.
stuff that's already done.
Okay, so that's, actually, if it isn't patented, it's a trade secret as long as it isn't published.
Well, the patents are already there,
Yeah,
but this is for production machinery, in other words.
the manufacturing,
Mhm.
which
Yep.
manufacturing processes can be trade secrets.
Absolutely.
but,
Absolutely.
yeah.
Have to use reasonable methods to protect them. So the next kind of category we go through is really putting together the deal team. And I think, one of the things that people always ask me about first is, what about investment bankers? Should I hire an investment banker? And I guess the things that you should be aware of are what an investment banker can do for you. And here are some of them. Obviously, if you're doing an auction, an investment banker can investigate, find candidate buyers. They validate your price. Even if you are not doing a competitive auction, it is important for you to be able to look your shareholders, your other equity holders in the eye and say, yeah, this is the right price. Well, how do you do that? Well, if you're not going to conduct a process, you want an expert to be able to tell you what it's worth. Question?
And what's their value? Is it a certain percentage of the transaction?
Investment bankers charge a success fee, and they usually also have a retainer arrangement. Retainer arrangement will be a certain amount of bucks per month on top of, and it'll be a success fee. And generally speaking, the success fee you'll get a credit against the success fee for any retainer you've paid. But these are other things that they do. They help orchestrate due diligence. They create data sites. Really important is they compartmentalize the transaction for the seller. There is no worse thing that can happen to you as a seller than have your business collapse in the middle of a sale transaction. And one of the things that lawyers and bankers do is they wall you off so that you can continue to do your operations and make sure your operations don't go into the crapper while you're trying to do a deal. Worst thing that can happen to you. They control intangibles. They deal with challenging times. They're hand holders, and also they're filters. They give you deniability. They can be your bad guy. They wear your black hat, just like a good lawyer does in the middle of a transaction. Legal and accounting professionals, you got to make sure that you're hiring these people, in reasonable advance. Why do you hire lawyers and accountants? Well, you want to know they're experts. You want to know that they have bandwidth, that they're accessible to you, there's depth. Chemistry is very important because these are people you're going to be living with for 6 to 9 months, and you want to make sure you can get along with them. Knowing what's market. I kind of dealt with this very briefly. It is important to know if a particular provision that you want is something that a reasonable buyer will agree to. Probably 30% of the arguments I have with when I'm representing a seller, the arguments I have with buyers or buyers' attorneys is this market? Is this what the market is demanding that you do right now? Let's go on. The due diligence. Okay, so getting back to due diligence a bit. Again, this is really kind of the way that your buyers find out about you. And I really use this phrase to make sure that the buyer knows what it's buying and the seller knows what it's selling. That is really the heart of due diligence. The other thing you need to know about due diligence is it doesn't stop with a questionnaire. It doesn't stop with an interview. It doesn't stop with a data site. It goes from the beginning of the deal to the end. A lot of people think they know what due diligence is. I will tell you most people don't. Because they assume that due diligence is if you tell a lie and somebody finds you out. Well, no. Due diligence is a reasonable investigation of you as the seller and your business, about you. It is not, as I say in the last thing, the existence of fraud does not mean that due diligence has failed. Because the more elaborate a scheme is in terms of trying to defraud you, the less it is likely that due diligence, reasonable diligence, will find it out. I can give you so many examples of situations where there were due diligence was performed and something fell between the cracks. And the reason something fell between the cracks is because somebody intended it to. Okay? Yeah.
Say an example of that, of the fraud. So the intent is not so much buyer to buy, it's to misrepresent.
Yeah. Let me give you one that happened to me about 8 years ago. I was representing the seller of a business. We were 4 days away from a closing. The buyer had done a very thorough investigation, we thought, and I got a call from the buyer's attorney, again 4 days before closing, informing me that our CEO had been leading a double life. He had 2 families. Okay, had really done a lot to make sure that that was hidden, but things happen, and that is not failed due diligence. So as I say, due diligence may not detect a complex, willful scheme. Okay?
But something like that, not that I'm in favor of someone having 2 families, but does that necessarily have to kill the deal?
Sure, your CEO is leading to. How are you supposed to trust anything they say? In another transaction that I dealt with, we had a CFO who had successfully hidden a criminal record for fraud. Does it really go to the business? Maybe not necessarily. The merits of business? No, not necessarily. But would you like to be explaining, you're a financial buyer, would you like to be explaining to your partners and the people who've invested in you that you bought a company knowing that the CFO had done time for fraud, or that the CEO had another family, lived in San Francisco, and another family in LA?
It's a super sensitive deal, and anything is going to throw people off.
Yeah.
It sounds like.
Yeah. Well, and in that particular transaction, the steps that we took, we fired the CEO. And basically we postponed the deal for 60 days, so essentially the due diligence could be redone. At our cost, by the way. Okay? So, due diligence, as I say, it stops only at the closing. These are some of the things. Any step along the way here is where you can be tripped up. And the reason I bring up the last one about those numbers is this is very popular. Somebody mentioned the idea of having a third party do due diligence. Happens a lot these days, and I will tell you, third parties like PwC is one of my favorites. They're hired all the time to do external due diligence. And what they are hired to do, they're hired guns, and what they are hired to do is to find problems. Not necessarily because the buyer doesn't want to do the deal, but because the buyer wants to do the deal at a reduced price. And a lot of times what you will find is at the last minute, there'll be, quarterly numbers that come in that don't quite make it. So what happens? It's a price adjustment. It's, a stall. It's whatever. Let's wait another quarter because the numbers didn't come in where we thought they would come in. All of this goes to the idea of credibility, and it goes to the idea of you are going to be accountable if you buy this business. You're going to be accountable for your investors, to your company, whomever, and these are 0-sum games. Yeah.
Better to deal with a privately held company or one that's traded?
I'm not sure that there's a difference between dealing with a buyer who's privately held and one that's publicly traded. Everybody looks at things the same way. A private company, they're going to have more communication with their investors than a public company is. But with a public company, you've got a big institutional holder. I don't think that there's a realistic problem other than the fact that a public company is at some point going to have to publicly announce to their shareholders that we screwed up. Obviously, it doesn't look good. As I say, due diligence is not a one-way street. You use the due diligence process, you use a term sheet, you use all of these things to find out about your buyer. Do they have the dough? Do they have the money? Do they have the willpower? Find out if they have a good integration plan, all of that stuff. A lot of people ask me people know the difference between financial and strategic buyers? This is kind of the universe of buyers. Financial buyers are essentially pools of money, okay? Private equity, venture capital. As opposed to strategic buyers are operating companies, okay? The world is kind of divided that way. The world gets a little bit blurred because what if you have a financial buyer, a private equity fund, who's bought a company and then that company buys you? So it gets a little blurred, and there's a lot of real generalizations out there about financial versus strategic buyers. Half of these things are probably white lies. Transaction pace. The idea is, hey, you're going to deal with a private equity fund, they're going to do this deal quickly. Maybe not. Purchase price. Financial buyers are always going to be conservative. Why? Because they're interested only in financial metrics. Okay, that's the idea. Buyer's objective. Okay, financial buyers, all they want is metrics, so they want EBITDA. But of course, a strategic buyer is very different. They want synergies. They'll pay a lot more for you because they see what the combination of your company and their company is going to bring to them. Again, this is more fiction than it is fact, but these are the generalizations that people draw. We're going to talk a little bit. How am I doing? Okay, we're doing fine. We're going to talk a little bit about term sheets. I think the thing that's important about term sheets are what they are and what they aren't. Okay, a term sheet is starting point for negotiation of substantive terms. That's correct. It is not the first step in the process. What's the first document you're going to be signing between a buyer and a seller? NDA, absolutely. So this isn't the first step, okay? It's non-binding, generally, okay? It's based on very limited due diligence. If you get a term sheet without somebody having done due diligence on you, the chances of that deal closing are very small, okay? Quick on the draw, premature term sheets it's almost a universal guarantee that you're not going to get a deal that's going to go to the end. It expresses a desire to proceed with a deal that has certain terms. Yep. It's a condition of allowing deeper due diligence. When you think about a term sheet, the way you should think about it is this. It is basically the dividing point between limited due diligence and deep due diligence. It's a prelude to a definitive agreement, fingers crossed. Term sheets are very different than they used to be. A lot of people, and me included, kind of look at the dividing line as being 2008, when we had the the Lehman debacle. Before that, I think that term sheets were much easier on both parties. They and in my opinion, if you look at them, very general terms. We're going to do this, we're going to do that. It'll be, we'll figure out the details, but they'll be customary. They'll be in marketplace terms. So that all they were doing is basically signing you up with the idea that the hard negotiations would come later. But what did the 2008 debacle tell you? They told you a couple of things. You can't trust anybody, and you got to do real deep diligence on everyone. Okay? So now they're more detailed. They're substantive. They get into the heart of the matter. Fewer wiggle words. Wiggle words, customary, standard, to be negotiated. All of those things which give the parties latitude. You want to nail people down. Okay? You also want them to be reciprocal. Remember I said about due diligence, the buyer diligence is not a one-way street? You want to use the term sheet also as a forum for conducting your own due diligence of the buyer. Do they have the financing to do the deal? Do they have the motivation to do the deal? What are their plans going forward? As I said, they're generally non-binding, but there are very important exceptions. Okay? Basically what is it? As I said, this is the dividing line of due diligence. So one of the things that's binding is you're going to let the other party do due diligence on you. You're going to take care of your own expenses. We're going to be keeping things close to the vest. The most important one, exclusivity. Most of the time, well, it always used to be the case. It's now less frequently so. But most of the time, a due diligence is the obligation that goes along with the due diligence. The obligation of a seller to a buyer is we're going to take this asset off the market. General exclusivity, about 60 days. But you have to realize when you sign a term sheet, essentially what you're doing is, for that short period of time, you're not getting any dough for it, because what the inducement for the buyer, this is the inducement for the buyer to spend its money to do due diligence on the seller. Okay? Duty of good faith negotiation. A lot of people don't realize this, but you really have a duty to be forthright and honest. If you don't sign term sheets, you don't intend to carry forward. And if you're a regulated industry, there are going to be some other things that are involved. I always stop when I start going through term sheets to talk about indemnification. Think of it this way. The purchase price is what you get, is what the seller gets. Okay? That's an important term. Indemnification is what the seller gets to keep. Okay? So the idea of indemnification is that basically the buyer is saying to you, okay, if you seller are not truthful to us in terms of the representations you make, or if you don't keep the promises you told us, we're going to be able to come back to you. And sometimes it will be, indemnification will be limited to a certain percentage of the purchase price. Sometimes that money will have to be escrowed. And in certain cases, there will be lies that you can tell that are so important and that go to the heart of the transaction so deeply that basically, if they're incorrect, the seller will be required to regurgitate the entire purchase price.
Do you put a time limit on indemnification?
Yes. Okay, for the way you look at the world for indemnification is this. There are fundamental reps and there are non-fundamental reps. Fundamental rep is, if you breach it, you have basically denied the buyer the benefit of the bargain. Let me give you the best example. I am selling 100% of my company, and I'm making a rep that I have good title in my shares. If I don't have good title in my shares, what has the buyer bought? Okay, fundamental rep, that lasts till the statute of limitations, usually. Other reps about, there's a contract that isn't quite right, or I haven't done everything I could to bring the deal to a close, or other things like that. The rest of the world is non-fundamental reps. Okay? Usually intellectual property, that you own it, that you're not infringing somebody else, is either a fundamental rep or it's a rep that has a longer life than a non-fundamental rep. Non-fundamental reps generally, at least a year, okay, maybe up to 2. As I said, fundamental reps, statute of limitations. Case of contracts can be 6 years. Okay? It is the single most intensely negotiated provision of every deal. Because it tells the seller, how well can you sleep knowing that you have all these dollars? Because if you've breached something, the buyer's going to be able to claw it back. Okay? Questions? Let's just go back to term sheets. I cannot tell you how many times people have told me, I'm going to sign it because it's just a term sheet. That is bad policy. And it's bad policy because the fact of the matter is that a term sheet is really a stage set. The other thing is it tells something about who you are, and it can ruin your reputation. So 3 rules. Don't sign a term sheet for a deal you don't intend to close, and I cannot tell you how often I've come upon clients who do that. Don't sign a term sheet with errors you intend to clean up later. It's just a nit. I'm going to sign it, get this done. No. The first rule, and I cannot tell you, I run into this 3 times every year. Somebody who comes to me and wants me to represent them, they're selling their business, and they hand me a term sheet that's already been signed. Bad idea. I cannot think of a single circumstance in my career, and I've been doing this a long time, where a signed term sheet did not have at least one material problem. And in some cases it's cost sellers a lot of money. Because they've said things that weren't true, because they've agreed to things they had no business agreeing to, because they didn't have the authority to enter into the term sheet, because they hadn't talked to their investors. It's just a universal rule, and I'm dealing with one of these right now, and we are in our second price negotiation with the buyer after signing the term sheet. Yeah.
Who prepares a term sheet?
It depends. If I am in a negotiated deal, think of the world in terms of transactions as being negotiated deals and auction deals. Negotiated deal is basically run by the buyer. Okay? In other words, the buyer is going to give you the term sheet. It's a one-to-one negotiation.
His team or the legal
Yeah. So there's that, and then there's an auction deal in which the seller is going out and trying to test the market, and usually using an investment banker to do it. In that case, the seller will be writing the term sheet and basically spreading it among the competitors so that they're all dealing with apples to apples in terms of the negotiation.
Is a term sheet negotiable? Is one party prepares?
Absolutely. And people who don't negotiate term sheets always regret it. Let's talk a little bit about a purchase contract. I think one of the most basic things that people don't realize is that basically all purchase contracts kind of look the same. It's all the same table of contents. I can tell you exactly the contents of a purchase contract. I can tell you, for the most part, I'll be able to tell you the section numbers. I'll be able to tell you the order in which they appear. What happens is the deal is basically layered over that table of contents. So what's the first thing? Sellers, reps, and warranties. How's your business doing? How are your financials? Do you own your intellectual property? Are you duly organized? All sorts of things fall under it. But one of the most important things that I do when I'm representing a seller is I'm going to be distinguishing between the things that you as a seller can say are absolutely true and the things you're not quite sure about. So the things that you say are absolutely true are flat reps and warranties. This is what is, okay? But then there are, this is to my knowledge what's true, okay? This is materially true. This is after my investigation, I believe this is true. There are so many different levels and so many nuances about levels of truthfulness. And you have to be careful, because how many things do you absolutely know is true about your business? Absolutely. I mean, can you say, for example, that I'm going to produce revenues of X 2 years down the road? Of course not. But can you say, I own my property? I own that patent, or I own that real estate, or I own that machine.
So, what if it's not a business? What if it's intellectual property, and you've gone out and you've already secured orders for the product, and you know the market where it's going to go? I mean, how do you value something like that?
How do you value? No, you find analogous cases. You seek out experts who can do that. I mean, one of the truest things that anyone has ever told me about startups and the way they form business is, number one, a technology is not a product. Okay? Number one. Number two, a product is not a business. I mean, if there are things that you want to remember when you're thinking about selling what you want to sell, and the reason that's important is because a lot of people spend a lot of time thinking that because they have a technology, they should be financing that technology. Financing that technology to develop a product in the hope that that product will mature into a business. It's one of the great fallacies of business, in particular startups. There are so many people who are out there. I mean, I've got a client now who's on their Series H round of preferred stock, okay? They have just realized that they don't have a business. You know, what they have is they have a very sound technology that they own and a very good product. But what happened was they got a letter of intent to acquire them. And the buyer was really smart. And the buyer said, what do you think the first question with the buyer? You have a great product. You have a great technology. You have a great product.
What do you want for it?
No. What's the next one? What's the next product? And they couldn't answer the question. Okay? And so what happened? Instead of selling a business, they sold a product. Did they do okay? Yeah, they did okay. But this was after, how many letters in the alphabet did it take you to get to H? But that was after, so many rounds of financing. And so it ended up that basically they were left with something they could have sold 5 years ago, gotten a really good price. These guys could have been going on with their lives, but instead they kept thinking that what they had was a business, and they never had a business. They had a technology, they had a product, but they didn't have a business because they could never articulate what the next product was. So, one of the things you have to know about when you're talking about reps and warranties, a lot of times they have duration qualifiers. This is going to be true for the next 3 years. And then, you think you've gotten through the due diligence process and you're working on the definitive agreement, and the definitive agreement will say something like, all of our contracts are in full force and effect. And then your lawyer comes in and says, well, not so much, because we have this contract that may have expired, you may have breached it, maybe not materially, but you've breached it. So then what do you have to do? You have to say, except for what's set forth in this schedule, these things are true. Those are the nefarious disclosure schedules. And obviously, they're really important when you're putting together reps and warranties. So you've got qualifiers as to knowledge, you've got qualifiers as to materiality, you've got qualifiers except as set forth, you've got qualifiers as duration. Think about this like a Rubik's Cube. And your lawyer's job is to basically sit down with you and walk you through these to make sure that you have appropriately qualified. You're not giving a flat rep when you should be giving a knowledge qualified rep. Purchase price. Everybody wants cash up front. But one of the things you really have to think about is, what if objectively a buyer can't get there? And in a lot of cases, you've got strategic buyers who have ground rules that have been set by their board of directors. And you have financial buyers who are answerable to their investors, and they've also set up rules. And maybe those rules don't get you all the cash you want. So the question is, how do you close the gap between what you want to get and what these folks can justify? And the answer is, you do that through some sort of deferred payment. An earnout which says, okay, I'm not going to get my $50 million up front, I'm going to get 25, but over the next 3 years, if certain hurdles are hit, certain milestones are hit, I'm going to be able to get additional dough. And you have to think about, and one of the first things let me give you an example. Right now I'm representing a company that's come up with a really interesting software that deals with immigration, Obamacare, and other issues related to staffing. It's a temporary staffing company. And the problem is that they haven't had enough operations to really justify the price they want. And so my first question to them is, okay, I know how much money you want. Do you have to have it on day one? And they thought about it and said, not necessarily. Okay, so what do you think are good metrics to measure if you've been successful as you're moving along? And we came up with those metrics, and over 3 years, every year for the next 3 years, if they meet the metrics, they'll get $60 million in total, which is more than their 50, but they only get 25 up front. And you really, as a seller, you want to know what your tolerance is for that kind of deal. And there are all sorts of problems. That's a typical earnout. There are all sorts of problems with earnouts. Okay, is the buyer going to be honest with me? So you want to have verification. You want to be able to audit. Am I going to be able to look at the business? Is my business going to be merged into another business so that I can't really identify what my successes are as opposed to the failures of somebody else? There are a lot of things that go into it, and you want to keep it fairly short term in terms of earnout, but is the way to fill the gap between buyers and sellers in terms of the value. Yeah.
What's the normal time frame? 3 years?
3 years is about the longest.
So
2 to 3 years.
Some deals are probably just like that.
No, you want to time test it a little. I've got a deal that I'm working on right now where it's kind of funny. The buyer offered an incredibly generous earnout, and the buyer has just awakened to the fact that they are going to owe about 4 times their highest bid. So we are now in the very, very nice position of renegotiating, basically going back and renegotiating the terms of our deal, because he's finally figured out that he blew the earnout. He absolutely blew it, and he is going to be responsible. He's going to have to answer to his shareholders, and he's going to have a real problem. But so you really want to analyze, the parameters of your earnout very carefully. Employees. A lot of people make the mistake of saying they've got key employees and they want to keep them in the dark. They don't want them to know about this because they want them to be running their business. Okay? The biggest problem with this is if you have a key employee and you've kept them in the dark, what do you give them at the end of the transaction? Transaction's been resolved, okay? All the terms are in place, and then you go to your key employee and you say, here it is. Want to sign up? The smart employee says, no. What do they have? They have incredible leverage. Incredible leverage. Some of the worst situations I've ever dealt with is you're waiting to close a deal and you have a key employee, a lot of times not a management guy, but a sales guy, who is basically saying, I'm not going to go forward with this. I want this and this and this and this. So it's very important to figure out when you're going to disclose. And you also have to keep in mind that salespeople, rank and file employees can be extremely important. You got to bring them into the process. If they're important, you got to bring them into the process. If you don't, you risk the idea that you're gonna give them incredible leverage at the end of the deal. Stock versus asset sale. How are we doing on time? We're doing okay. Stock versus asset sales, okay? Golden rule. Sellers want to sell stock. Why do they want to sell stock? They want to wipe their hands, and they want to sell liabilities as well as assets, okay? And that's the way you do it. You sell stock. Buyers want to buy assets. Why do buyers want to buy? Why do they want to buy assets? They don't want to buy liabilities. The other thing is, they want to step up in their asset basis, tax basis of assets. You get that when you buy assets. You don't get it when you buy stock. Okay? When you are buying stock, you are buying all of the assets and all the liabilities. When you're buying assets, you are only buying specified assets, and you're only buying those assets. Subject to specified liabilities.
Would that be a deal like you get to restart your depreciation on a machine or something?
It could be. It could be. There's lots of examples of, particular situations where a stock deal is more important. One example is also, I'm selling you. One of my big assets is our contracts. Okay, those contracts are not assignable. They say that you can't assign it. But what if you're selling your stock? If you're selling your stock, you're not assigning any contract. So you get around that by basically selling stock. You don't have to worry about parsing out each individual contract. This is real important, and basically it is, you have to figure out, when you're going into a deal, you have to figure out what are your gotta-haves. And your gotta-haves are often its price, but it can also be its employees. These people have worked for me for 30 years, I want to protect them. You just have to figure out when you go into a transaction, you have to figure out what is most important, because a buyer is never going to identify that for you. An investment banker or lawyer may help you, but a buyer could care less. So you really want to think about the things that are important. Is the brand important to you? The legacy of the company going forward, is that important to you? You have to figure this out. A couple of rules that I come up with. Some of these are pretty obvious. Some things aren't for sale. You have to figure out, what isn't for sale. If somebody wants to buy your company, but a precondition of that is that you fire your 20-year CFO. Okay? Trust your neighbor, but brand your cattle. There is an oral agreement is worth the paper it's not written on. Remember that. The integration clause, this is really a follow-up for that. Most people, when they're confronted with a contractual promise, and they say, and you look at the documents, and the documents they're not consistent with that, with what the parties understood, it's because, he told me that. Or there was a telephone conversation. That's the integration clause. Good contract will say. This agreement, together with the exhibits and disclosure schedules attached hereto, constitutes the sole and entire agreement among the parties regarding the subject matter hereof. It supersedes, it replaces and supersedes any other documents, discussions, etc. That's an integration clause. It is one of the things that people most commonly get stuck on. If it's not in the written agreement and you have an integration clause, and I consider it to be malpractice if there isn't an integration clause, if it's not within the agreement, it doesn't exist. Penciled down, no kidding. The reason I bring this up is it used to be that a buyer, when they hit a rough spot in a transaction, would say, pencils down. And after a while, everybody understood that was code, and it basically meant pencils down for tonight. But I will tell you that as buyers, strategic buyers, financial buyers, are looking at the universe of things that are available to them to buy, they're not kidding you when they say pencils down. Because in a lot of cases, they're working on 2 or 3 deals at a time, And they have in their own mind a queue. And if they find that one deal is more difficult than they ever thought, they'll basically take the guy at the front of the line, and if they can't reach agreement, they'll drop him to the back of the line, and it'll be pencils down. The very important thing about today's deal environment, time is more valuable than money. People who are out buying businesses are generally not just looking at yours. And a lot of people don't realize that. And so, we talked about due diligence on the buyer. One of the things you want to find out is how many other deals is the buyer looking at? Does they have the bandwidth to do my deal while they're looking at some other deal? Are they looking at a deal that's a lot bigger than mine? Are they looking at a deal that is strategically more important than mine? Those are the kinds of questions you're getting to ask. Because if they don't have the bandwidth, you're going to find yourself, victim to another transaction or another two transactions. Find yourself at the end of the line. And what does that mean? It means that when you are trying to keep your profits up and your operating results up, you've got to do it that much longer to keep their interest. Okay? Allocation of risk. This is a favorite topic when you are arguing about reps and warranties. Allocation of risk means who knows, when you're talking about a rep or a warranty that's going to be made, who can better control that fact? Who has more knowledge? Who can better control it? Allocation of risk is one of the things that I use a lot when I'm negotiating. No, you can't ask my client to do that. You have more control over the operative facts. You're the one who can decide if a particular product will be introduced and its timetable. You, not the buyer. The last thing I would leave you with, I think, there is one other thing. No such thing as boilerplate. Roger, I may have told this story when we were doing the presentation I made to you guys at Enosphere. I had a transaction a little while back, actually it's a long time ago, where I basically inherited a company that had entered as a client who had entered into an agreement. And it was an agreement for the sale of some assets, oil and gas assets in Australia. And so the parties got at loggerheads. And the client came to me and said, so we've got this dispute. So, look, it's governed by Colorado law. You're a Colorado lawyer, no problem, right? And that was fine, except for the fact that the agreement also said, any dispute regarding this contract will be brought before the Supreme Court of Western Australia. So I spent 6 weeks of my life in front of guys with white wigs arguing that case. There is no such thing as boilerplate. The way I read a contract, and boilerplate is always one of the things that's going to be at the end. It's the last article, right? It's miscellaneous or general matters or something like that. The way I read a contract from front to back, and then I read it from back to front. And I read it in its entirety from front to back, and then I read each section from the back going forward. I read each section like a separate contract. And when I'm looking at each section, what I do is, so say the quote boilerplate is Article 10. Okay, so I'll read Article 10. Then I'll read Article 9, and I'll read it in connection with Article 10. I'll read Article 8, and I'll read it in connection with Article 10. Get the picture? The idea is very simple. Things are boilerplate until they're not. And then they cost you a boatload of money, and they result in some very unfortunate results. Oh, that was the end. Any questions? We have just finished 4 hours of stuff in about 55 minutes.
I guess I do. If I'm the seller and a buyer comes in, and we do the exclusivity, say off the timesheet, or make that part binding, and I have another buyer that they don't want to engage because they know we're exclusive. Then my first buyer backs out. Can I have a clause for some sort of liquidated damages if they
Well, usually,
a
well, let me
list.
tell you how that works in an auction context, okay? In an auction context, if I've got an investment banker, and the investment banker, the object is always to thin the herd, okay? Get it down to the most serious buyers. So what you do if you're an investment banker and you find somebody who is your best buyer, you say, look, you're it. But what you tell the next guy is you say, look, we're under exclusivity now. Can't deal with you. But if this falls through, we're coming back to you. And it's almost like selling a house.
Like right of first refusal?
Well, it's not a right, it's less formal than that.
They're likely backup.
Yeah, they're a backup, it's a backup offer. And most of the time when you have an auction, that's the way it kind of works out. That you'll have somebody and you'll say, look, you'll identify the best offer and you'll say to the next guy, say, look, we have to run through the process with this particular buyer. If this doesn't work out, and we'll know in X number of days, we'll come back to you. What I usually do when I'm negotiating exclusivity clauses, the worst situation where you have exclusivity is you enter into exclusivity on day one, and on day two, the buyer comes back to you and says, remember that deal we talked about? Well, the price is half, okay? This does happen. And what I try to do is I say, look, we'll give you 60 days exclusivity, but if you change a material part of the contract, a material term of the contract, exclusivity ends. You are on a level playing field with everybody else. And quite frankly, most buyers are willing to accept that.
Because you're only exclusive on the terms you know.
But most exclusivity provisions don't have that. It's basically, you're in for 60 days, Yeah.
Since an auction contract would be more generalized in most of the terms,
Only up to a point. The way you do an auction deal is this. You send out to all the people who've been identified as being competitors, you send them all out the same contract, and then you have them mark it up and send it back to you, so you're dealing apples to apples. But it gets very specific. Okay, it starts out as general because you have a universe of buyers that you're appealing to. But the idea is they all mark it up and then they send it back to you. So when I'm representing the seller, what I'm doing is I'm comparing apples to apples. I know what my deal was, and I'm comparing. And what I do is I compare a grid.
well, I guess I was envisioning the potentiality of an auction contract either being a closed process where the highest bidder or whatever the terms are.
Never.
Right. But is there a process where you would have a two-step? In other words, an auction that when the selected buyer out of the auction would then enter into a more specific.
The way it usually happens is this. I start off, you send out a teaser to the universe of buyers.
Right.
What you are looking for is what we call indications of interest, which say, yeah, I'm interested in that. I'd like to see more materials.
Who
Okay.
makes a prospectus after that?
It's called a SIM, a confidential information memorandum. Okay. So if you indicate that you're interested, and you give kind of the broad parameters of your interest, you will then get an NDA. Based on that NDA, you'll get a confidential information memorandum. You go back through that, and then a couple of people in discussions with the investment banker say, yeah, I'm really interested. Okay, what do you say? You say, we need a letter of intent from you. In a lot of cases, I will, as counsel for the seller, I will circulate a form letter of intent. They then come back, we then narrow it down to 2 or 3. At that point, what we do is we then send out a form contract. And now usually you get down to 2. And then it's basically a battle of the contracts. And then the winner of that battle, you enter into a letter of intent with, and you go from there.
It seems to me that the seller in that situation would have a tougher process for due diligence because he's looking looking at a lot of potential people, and he's gonna select.
Well, no, in a letter of intent, when I'm drafting a letter of intent, I will say to the buyer, I want to know your financing sources. I want to know, the approvals you have to go through internally in order to, I will identify certain things that I want to include in the letter of intent to satisfy what I think are my obligations to do due diligence on the buyer.
Okay.
Okay? Yeah.
Is there a price window that these kind of auction contracts would go through? I mean, like, you think that the business is worth 100 million, 50 million, is it 10? I mean, is there a range?
Sure. Yeah. You will, and you'll ask for that range really up front. You'll say, somebody will come back to you and say, yeah, I like that. And you'll identify, you'll come up with a range.
Will you do evaluation before you go through that process?
In a lot of cases now, they do what's called, what I'm telling sellers to do now is do what we call a Q of E, a quality of earnings analysis, because every buyer does that now. And what they do is they hire my favorite guys, PricewaterhouseCoopers, and they go and they do a quality of earnings analysis. I want to have my own done as counsel to the seller so that I have a rebuttal for the bullshit that they're going to give me. It's a real common thing these days to go out and have done, as a seller, have done your own quality of earnings report so that you're prepared to rebut the one that the buyer is inevitably going to do.
Are the deal hang-ups more on price or a particular term?
Indemnification.
Because that's the major.
It's first price, but after price, it's indemnification. And after you get past price, it's always indemnification. But indemnification has a lot of pieces to it. Indemnification starts with the reps and warranties and works your way through the covenants, and then you talk about how long is the indemnification going to be, where is it capped, all those things.
Like 6 to 9 months to get through this?
Negotiated deal on the short end, probably 3 to 6. Okay. Auction deal, 6 to 9. Unless lightning strikes. And when lightning strikes, it's in the form of what they call a preemptive bid. You have one bidder who says, I'm in love, I need this asset, it's a unique asset, I'm never going to see anything like this. I am going to give a preemptive bid, which means a bid that nobody else in their wildest imagination would ever do.
So like a really nice synergy of what you have is what they want.
Yeah, essentially.
I'm going to go back on a prior question that I asked. On the negotiation of the terms in the term sheet, once you negotiate those prior to the signing,
Mhm.
Are any of the terms negotiable after the signing?
Sure, based on due diligence. Yeah, it's always so, yeah, as I said, due diligence is really kind of, it divides preliminary from deep dive due diligence. And every term sheet is always going to say, this is subject to our due diligence investigation. So
I guess that's based on disclosure after the signing.
Mm-hmm. Mm-hmm.
Okay.
And you set up a data site and you go through that, and yeah, it's a process.
You mentioned data site a few times. Can you describe the data site?
Data site is essentially a site that's usually established. We do it, or an investment banker does it, and basically it's a Dropbox. And what you do is you don't make the entire Dropbox available to the buyer. You stage it so that you're really getting down to levels of detail when you're getting much closer to a closing. Worst thing you can do is do a brain dump into a data site, because that's when you really put your confidential information at risk. Okay. Thanks for your attention. Appreciate it.